Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, I'm Rahmat Muhajir Nugroho from Ahmad Dahlan University. I want to present my article entitled Implication of MKMK and Administrative Court Ruling for the Constitutional Court's Chief Justice Status. Presenter, I'm Rahmat Muhajir Nugroho and my friend Intan Suraya. First, I want to explain background to the problem. The trigger case. The Constitutional Court issues decision number 90 PUU 21 2023 regarding age limit for presidential or vice presidential candidate. Conflict of interest. Chief Justice Anwar Usman participated in the decision benefiting his nephew, Gibran Rakabuming Raka, raising serious ethical concerns. Ethical sanction. The MK Honorary Council Decision Number 2 MKMK L 12 2023 found Anwar Usman guilty of serious ethical violation and removed him as Chief Justice. Legal controversy. The Jakarta Administrative Court later issued decision number 600.4 G 2023 PTUN Jakarta declaring the MKMK sanction invalid. The core issue. This creates a conflict of authority between the international ethical body and the administrative courts, raising questions about judicial independence, the judge involved. Method, research type, normative legal research. Approach, analytical and descriptive approach, focusing on the study of legal norms. Data source, secondary data comprising primary, secondary, and tertiary legal materials. Includes legislation, court decision, legal literature, articles. Objective, to evaluate the relationship between internal ethical oversight mechanism and state administrative law and their impact on the constitutional justice position. And then research result. First, authority analysis. Does the administrative court have the authority to annul to the MKMK decision? Finding. The Jakarta Administrative Court does not possess the authority to annul MKMK decision number 2 MKMKL 11 2030 23. Reasoning first. Reasoning 1. Nature of MKMK. MKMK is an internal ethical body, not a state administrative body. Its authority is limited to enforcing the code of ethics. Reasoning 2. Not KTUN. The MKMK decision does not meet the requirement of an administrative decision or seeking or KTUN because it lacks public legal consequences and is binding on reasoning 3. Civil exclusion. Ethical enforcement process, hearing, evidence, assessment are internal judicial action excluded from administrative court jurisdiction under Article 2.A of the Administrative Code Law. And then result 2, impact on status. Impact of PTUN decision number 600.5.4 G 2022 PTUN Jakarta on Anwar Usman. Restoration, restoration of honor. The PTUN decision explicitly restore Anwar Usman dignity and standing as constitutional court justice. Position reinstatement. While his dignity was restored, the veteran rejected his request to be reinstated as Justice, confirming the appointment of Suharto as the new Chief Justice. Author's critical analysis. Despite the legal restoration of dignity, Anwar Usman was factually proven to have violated principles of impartiality, integrity, and competence. The author argues that due to this serious violation, he should ideally be dishonorably dismissed to maintain the credibility of the Constitutional Court. Conclusion. Authority. The Jakarta Administrative Court, or PTUN, lacks the legal authority to overturn MKMK decision number 2, MKMKL 11 2023, because the ethical decision does not constitute of a state administrative decision. The primary impact of the PTUN ruling is the restoration of Anwar Usman's dignity and honor, allowing him to continue serving as a constitutional judge, though he remains removed from the Chief Justice position. My article is enough. Thank you very much for attention. Assalamualaikum warahmatullahi wabarakatuh.